Am I audible, Riddhi? Clearly?
Yes, Shravan, you're audible.
Great. Greetings, everyone. I'm P. Shravan Kumar, the founder and CEO of SK Associates and Group. I'm your host for today's conference 1.2 on emerging entrepreneurial trends in arbitration, mediation, and ADR. I would like to request all the speakers and attendees to kindly switch on your webcams and stay on video throughout the conference. I'd also like to request you all to actively participate in the calls being conducted in the chat box. Now, I would like to quickly introduce our guests for the second session of Conference 1.2. Firstly, I would like to introduce Dr. Teresa Parnell, who has over 30 years of experience as a mental health professional with a focus on families. She now spends her professional time as a mediator, neutral process facilitator in collaborative family law cases, co-parenting consultant, and parenting plan consultant. She is a licensed psychologist from the Florida Supreme Court, certified mediator, appellate circuit, county, dependency, and family cases, accredited collaborative professional, elder caring coordinator, and a certified addictions professional. Dr. Parnell has been involved in several projects to provide collaborative services to low and moderate income families. Dr. Parnell is also a collaborative process trainer with roadmaps for resolution. Next, we have Advocate Pushpa Gupta, who is a law graduate from the most prestigious law school of India, Campus Law Center, University of Delhi, and was admitted into the bar in 1994. She did her LLM from University of Northumbria, Newcastle, United Kingdom, EC Commercial Laws. She has held multiple designations of great repute, such as representing Government of India, Ministry of Environment and Forest at National Green Tribunal, New Delhi, lead trainer for Indo-British Advocacy Skills Project, and has trained more than 800 lawyers across India in advocacy skills, international certified mediator, International Mediation Institute, IMI, Hague, Netherlands, certified commercial mediator from Indian Institute of Corporate Affairs, Ministry of Corporate Affairs, Government of India, mediator at Honorable Supreme Court of India, mediator at Capital Court of India, that is Delhi High Court, and also at the District Court of Capital. Experience of more than 12 years in mediating, negotiating, and conciliating in more than 550 cases. Next, we have Mr. Harbansh Kumar Chaturvedi, who is an erudite in the field of law, having expertise in the sphere of criminal, civil, corporate, service, labor, and industrial, intellectual property rights, international, commercial, and arbitration law. He is a practicing attorney, having over 29 years of experience, and is the founding and managing partner of HK Law Offices. He is designated as an advocate on record in Supreme Court of India. He is a panel arbitrator in various renowned institutions, including Delhi International Arbitration Center, Telecommunications Consultants India Limited, and Bharat Heavy Electricals Limited. He is also a senior mediator in Delhi High Court Mediation Center since 2008 and is a senior advocate, having mediated over 1,000 plus cases. Next, we have Ms. Aksana Shalga, who is a PhD scholar in psychology and an associate professor and mediator. She is an associate professor at the Education, Psychology and Personality Development Department, BSPU, named after M. Tanka, Chief of the Education and Practical Institution. She is also a director of an NGO titled Belarusian League of Family Mediators. Next, we have Dr. Amna Mirza, who is an alumni of Delhi Public School and St. Stephen's College, Hindu College, and has done her MPhil and PhD from University of Delhi. She is currently an assistant professor of political studies at SPM College, University of Delhi. An avid traveler, voracious reader, and vegan, her academic initiatives took her to University of Duisburg, Essen, Germany, University of Freiburg, Switzerland, among others. She is the recipient of Godfrey Phillips Golden Ovary Award, St. Stephen's College Centenary Medal for Character Combined with Learning, Bharat Nirman Award for Women Entrepreneurship, Mook Nayak National Award, Business Rankers Women Achievement Award, amongst others. She has been associated with art and culture festivals and regularly contributes columns to several newspapers and magazines. She has also pursued additional coursework from Harvard X United Business Institute, Belgium. Last but not the least, we have this Begam Muktinova, who is the CEO of the IT company Businesssoft and an arbitrator at the International Court of Arbitration in affiliation with the Chamber of Commerce and Industry of the Kyrgyz Republic, Kyrgyzstan. She is also an arbitrator of the Bishkek International Arbitration Court on Subsoil and Commerce, mediator, IT consultant, advisor to the chairman of the International Arbitration Court of Tashkent, advisor to the chairman of the International Commercial Arbitration of Tajikistan, member of the Association of Lawyers of Kazakhstan, member of the Management Board of the Republican Community Mediators, and member of the National Mediation Center, Belgium. Regularly participates in various trainings on arbitration, mediation, and IT. Now, I would like to invite Advocate Riddhi Bhanushali from the Mumbai High Court, my co-host, to take it. Thank you.
Greetings everyone. I'm Advocate Riddhi Bhanushali, the Chief Strategic Alliance Advisor of SK Associates and Group and Shravan's co-host for the day. I would like to request all the guests and attendees to kindly switch on your webcams during the conference. I would also like to inform all of you that Ms. Vaishali Shri is conducting polls in the chat box and team are conducting polls in the chat box throughout the session. Do actively participate in the same by giving your opinion on the polls. Now, I would like to invite Dr. Tarisa Parnell, a licensed psychologist and certified mediator from the Supreme Court of Florida, to commence her speech.
Hello, good evening to those of you who, I think was probably most of you, are in the evening time. I'm here in the morning, so starting my work day, so fresh and lots of energy. So those of you who are waiting for the day, perk up, and hopefully the next hour or so will be interesting enough to keep you engaged. So I was fortunate to be able to listen to most of the speakers yesterday, and then went back and listened to some on video. So that's a great option as well. And I do have a few comments to make that are going to overlap with yesterday, but I'm going to try to keep those to a minimum so it's not and take a little different direction, so it's not a total repeat. But there are a few things that I think are worth repeating. So those of you who attended yesterday may hear a few items that you heard touched on yesterday. Where I want to focus is to talk about being an entrepreneur in the area of being a mediator. Mediation is not the only alternative dispute resolution process that I'm involved in, but in the interest of time, I'm going to focus on that area. But first, I think it's always important to consider context. And, part of what I found so valuable about yesterday, and I know will be valuable about today, is that the group of speakers come from really different circumstances and situations. And so you're getting a really broad view. And that context is important to understand sort of where someone's experience comes from and how that guides the information that they have to share with you. So as has been mentioned, so I can skip some of the intro part and I'll make it quick. Thank you for the nice introduction. I'm a psychologist. I'm not a lawyer. And so that influences the work that I do. And but I've spent most of my career working with families who were embroiled in one sort of legal dispute or another. And that's how really I came to this work of wanting to be a mediator. And early in my career, I was exposed to mediation. So in Florida, I was certified as a mediator, which I'll talk about in just a moment, in 1994. So I've been doing this for quite a while. And as I said, it was through those family disputes that spilled over into the legal arena that I became exposed to mediation and was really intrigued. But early on, I had lots of other work, doing lots of other things in the area of psychology, and didn't pursue a lot of mediation work. And about halfway through my 30 plus year career, I really wanted to focus more on alternative dispute resolution and began to make a plan for how I was going to do that going forward. In the United States, for the most part, the states determine the rules related to professional services like mediation. Now, I know that mediation can take many forms, and there's lots of valuable conversation around the concept of the definition of mediation and whether mediation is a profession, whether training and certification should be required, and all of those things. I think that's beyond the scope, at least of what I want to cover today. But again, in terms of context, it's important to know that I come from a place where mediation has had a foothold for decades. It's in the statute. There are rules of procedure. There is a process for training. There's only certain training that qualifies. So there's identified trainers in the state of Florida. You can't just come in and do training and have that qualify for your training, for your certification. And there's a specific certification process that looks at not only the training you receive in mediation, but your educational background, your professional background, how many mediations you've observed or co-mediated. So there's a very specific process for being certified and lots of rules. There's also a disciplinary board. So that's the system that I come from and have the privilege of being able to participate in. All of that being said, you can in Florida choose any mediator you want. So you don't have to choose a certified mediator. However, most of the mediations that occur are with mediators who are certified. I do not work directly for the Supreme Court of Florida, but the way certification is done here, you are expected to state that you are a Florida Supreme Court certified mediator, because that's the only recognized certification of mediators in the state of Florida. Again, that doesn't preclude someone from being a mediator here, but that's going to be a much more difficult path. The other thing that is important for me to refer back to is most of the mediators in Florida where I practice are lawyers. You don't have to be a lawyer, obviously. I'm a mental health professional. There are accountants, there are teachers, there are physicians, there are all types of professions that decide that they want to be a mediator, part or full-time. But it is not the more common path. And it certainly creates some particular types of what might be considered challengers or obstacles for someone who's not a lawyer who wants to mediate on a regular basis. The other thing to know about Florida is that there are different categories of certified mediators. So here in Florida, we have county, civil, family, dependency, and appellate mediators. And you are required to get certification in all of the different areas if you want to be considered a certified mediator in the specialty areas. I'm certified in every one of those areas in Florida, but I mostly, almost exclusively, do what are considered family law mediations. So it's folks that are going through a divorce, folks that were never married, maybe a same-sex couple, maybe a couple who is negotiating prenup or a postnup. All of those types of things that relate to a family structure are the types of mediations that I participate in. So moving from there, so now that you know context and thinking about this concept of entrepreneurship, one of the focuses of this conference, I want to share some comments with you based from two perspectives that I think are relevant and that are topics that I know a little bit about. One of those is being a business owner. I have been practicing for more than 30 years, and for 25 of those years, I have owned my own small business as a psychologist / mediator / dispute resolution professional. That's what I do, and that's what I've done in my own practice for the last 25 years. The other way that it is relevant in my work, I think, to this conference is this concept that I mentioned of picking a path where being a psychologist is not typical. And so I chose to tread along a path that's not often tread by someone like me who has the background that I have. And so that's required, I think, a certain level of creativity and how I approached being this business owner to be able to get out of it what I want, my definition of success, which may not be 100% other folks' definition of success on this call. But to get out of this experience what I wanted, I had to think about my path on this path being maybe a little bit different than some. So when, so what do I want to share with you then about how to be, to maybe achieve the things that you'd like to achieve as a business owner of a mediation practice. And I want to start with this concept of being deliberate. And this is where it's interesting. As I listened yesterday, there's a few concepts I'm going to pepper through here that I had planned that were mentioned yesterday, and I've left them in because I think they're worth repeating for the students and professionals that are on the call. So for me, I already mentioned that about halfway through my career, I decided I wanted to deliberately spend more of my professional life in alternative dispute resolution services. And even though I was certified as a mediator, that doesn't just suddenly bring you work. It doesn't just appear on your doorstep because you hang out a shingle saying that you are a licensed psychologist or a certified mediator or a lawyer or anything else. So for me, it was designing a deliberate plan, and I happened to need to think years ahead, not months ahead. So for me, it was deciding where I wanted to be, developing the steps for how I'm going to get there. It doesn't always work out as planned, certainly didn't for me. But by having a deliberate plan, then when you are shifting from how you originally thought you would do it, there's an opportunity to make those shifts and those changes in an organized sort of manner, and again, in a very active and deliberate sort of way. So it's being deliberate about where you want to be and be deliberate about how you're going to get there. For me, it was a combination of some of the things that I'm going to talk about here along the way, but briefly, for me, it was a series of steps that involved additional education, volunteering my time, and increasing my opportunities to mix and mingle with the types of people who were doing the work. Not the same as marketing or putting my hand out for business, but mixing and mingling with the people that are doing the work so that I could learn and understand what was going on in the context of my community. And so that's really the next big part. What is the context within which you are working? And so I could talk all day long about my context, right? I shared it because I think it's important in framing my comments. But if it's not the context within which you are trying to build this mediation practice or business, what I'm going to have to say about that context may not have as much relevance. I think some of the other things do, but you have to know very, very clearly what is the context within which I'm working and where is my community in the history of mediation. And so many of you are not going to be working in situations where mediation has been occurring in your area in an organized, structured way for 40 years. So what is the context within which you're working? The second part, though, is within that, finding your uniqueness or your niche. I don't have experience working in corporations. I don't have experience being the owner of anything other than a small business. I don't have experience with estates and that sort of planning. So while I might have general mediation skills to mediate those types of disputes, I'm going to lack some information and knowledge that could be critical to a particular mediation. And I need to be really self-aware with regard to that. And I need to be transparent about that with folks who are seeking me out as a mediator. Does that mean I don't get any of those disputes? No, I sometimes do. And in fact, usually when I get those kinds of disputes is because there's a family overlay or there's an emotional overlay, and they've already tried mediators that knew sort of the law and the background, and for that particular situation, it wasn't going to work. But those are less frequent than the scenario where my background that people who might be looking for mediators need to know about is that I have all of these years working alongside family law as a psychological evaluator.
Excuse me, Dr. Parnell. we are on a schedule. So if you could just wrap up soon. Yeah.
Sure. Okay. So working as a mediator, working as a psychologist in my background, I've worked in criminal court, I've worked in dependency court, I've worked in family court as a psychologist. And so when you have a complicated family situation where maybe there's high conflict and you have a parent who's been accused maybe of some impropriety or has something criminal hanging over their head, I have the background to be able to understand all of those systems and how they interact with each other and how they might impact children. The other part is getting out of your silo. If you're a lawyer, don't just hang with lawyers. I don't just hang with psychologists. You need to be interdisciplinary because we think about mediation and alternative dispute resolution differently. We use different language and we can learn from one another. The next part is to prioritize your tasks within your business. People always come first, money comes second, and business processes come third. If you make the people that interact with you feel like they're an annoyance because you're too busy with your business processes, you'll have lots of time for your business processes because you'll have no customers. So people always come first. Spend your time answering their questions, making them feel important, solving their problems, providing input. And if you're not the right professional for them, referring them to the right professionals because they will remember that. And it will help you with your work. The next one, I'll skip over so I can speed up. Give your time away. There's always value in giving your time away. You will learn from the work that you do, whether it's teaching or whether it's providing pro bono mediation. You will reap benefits. It could just be hearing gratitude on a day where it feels like nothing's going right in your business and you have an incredibly grateful client who knows they would never get this service otherwise. And it might bring work to you, but that can't be the motivation, but freely give your time away. Two more things and I'm done. Always be a teacher and a learner. At the point at which you think you're only a teacher because you have nothing else to learn, your business will actually suffer. And last, always provide quality, competent work. It may seem obvious, but it happens all the time. And this is still the example. I have a new landscaper, fantastic at the beginning. Now he's so busy, the quality is diminishing. He will not sustain, and he certainly won't be doing my business building very much longer because whenever you get away from the quality of work, then again, you're going to lose the opportunity to have customers. So that was 11 minutes, I think, from my start. Is that good?
Actually, your points are quite valid, Dr. Parnal. In fact, the last one, as you emphasized on it, the quality of businesses like diminishing day by day. That's something actually even I am Riddhi believe in. Thank you for your speech. I would like to request you to share your mail ID in the chat box so that if anyone has queries, they can directly mail you out there.
I'm sorry, you share my what in the chat?
If you could just share your mail ID in the chat box so that if anyone has queries, they can straight away mail you. Yeah. Thank you. Riddhi?
Yeah, sure. I would like to thank Dr. Parnal for her amazing speech. Moving ahead, I would like to invite Advocate Pushpa Gupta, a mediator at Supreme Court of India, to commence her speech.
Yeah, thank you, Riddhi. First of all, I must congratulate Shravan, Riddhi, Vishali to just think about this conference where we can have so much of exposure while learning from each other, because it's an august gathering of speakers from different countries. So hats off to you guys. We were nowhere near you in this age the way you are doing, so it's completely hats off. I'll just rephrase the topic which you've given to me because that will relate to what I want to speak on this, because it says emerging entrepreneur trends as far as arbitration, mediation and ADR is concerned. I would say I'll restrict myself to mediation. I'm not going into arbitration, and there are other legs of ADR also. But I'll say that if you come across mediation training, mediation skills, certainly it will make you enhance in whatever field you are. You will emerge out as a winner. You will emerge out as a successful person, because in every relationship of our life, be it personal or professional. Two things are very important, that is communication and understanding. Without this, you cannot achieve what you want in relationship. You cannot keep your ties intact in any relationship. So to talk about mediation as something as a profession, we'll deal with that later because our time slot is already restricted. But my request to all of you, I can see we are around 30 people, maybe a little more than that, and we are on YouTube also. There are more people who are viewing us. I just request all of you and each one of you and my co-panelist, Mr. Harbans Chaturvedi, he's a dear friend and a senior colleague at PAR from Delhi High Court. We see that whenever, we had this mediation training 12 years back. We are enrolled at bar from 94. That was, we got mediation training much later in our life, and the way you people are interacting. So my request to all of you is that please take out time to just go through this mediation training. It's just 40 hours of your life. It transforms you as a person. It gives you those life transformation skills because first of all, if you're thinking of starting any startup in which you people are giving consultation to many people to start up, but if you are starting up with any business, there also you'll meet people, you'll meet people within the organization, then you'll be having business relationship outside your organization to build up your turnover and all. So it speaks about two people. And two people, if they are not able to communicate well with each other, how would they be generating a work, a business for their organization, for their business house? So what mediation tells you is that it's always good, even if we disagree with someone, if there is a behavior to disagree with someone. If you are in competition with someone, that competition itself can be healthy. It is not that you have to be critical of every competition. If you are jealous of someone, which I think everybody possesses those qualities, we keep them here in our head, jealousy, competition, that is there. We are never happy because we are in a competitive world. And we have seen that our present generation, we are into competition because there's so much outside, lying for each one of us to explore. It's not that earlier we used to choose one profession and we used to carry on for next 30 years. But now we are putting our hands in different fields, not just one. And every field requires our relationship and connect with the other side. And this mediation tells you that yes, if you respect the other person's perspective, other person's viewpoint, why a particular person is asking for a particular thing, because business relationships is again give and take, profit and loss. So profit and loss is also part of this. Any deal, any agreement, there are terms in the agreement. There may be disagreements. So those disagreements are often taken as not in a good spirit. So we just disassociate ourselves, we just cut our relationship. Okay, we will not enter into relationship business with you. We'll go with someone else. No, that is not. Mediation tells you to be patient, to just step into these other person's shoes and see as to why that person is asking for a particular thing. Another very important aspect of mediation 40-hour training is that every business house, there has to be some negotiations. Those negotiations involve bargaining. So if you go through this 40 hours technique, skills of mediation, you'll be emerging as a better negotiators for your own business houses. You'll be able to trade off as to what suits you, what suits other side also, which is again a win-win situation. The percentage of profit. So there's so much attached to this mediation skills itself. Me and Dr. Teresa, I have other friends, Ms. Begum, we all are, into an open world. I'm a lawyer. Then we present our case before the Honorable Court. So my advocacy has improved after me going through this 40 hours. I know where to put a break in my life, where to put a break in my presentation. So these are the benefits, where to put a pause, where to give a listening to the other side. You need all this, if not as a lawyer, but even in any other startup, in any other business relationship. And mind it, not just your professional, life, but your personal life. If you know these skills, you'll be able to have a happy home. You'll be able to have a happy family within your life. So, if a happy life is there at home, you can just work out well outside. But if you can't handle your home, then how can you run a successful business outside? So, mediation gives you a combo package of coming out a person who maintains, builds, bridges relationship within the family and in profession. So I call this mediation as something prevention is better than cure. So if you know how to talk, how to communicate with someone, how to put a full stop while you're talking, where to put a break in life, where to understand how to understand other person's perspective, you can certainly prevent lot of conflict in your life, lot of disassociations from your business houses. So it's good as not just as mediator, but just taking a training of mediation, not to become just a mediator, but to be a better person with life transforming skill. It is an added advantage. Now I'll take 2 minutes of your topic, that how good it is as an independent profession. See, it definitely has lot of scope in those countries which already have rules, regulations. As Dr. Teresa is informed, they already have a law, legislation to that effect. And India is not very far off from that good day, which is soon going to happen, maybe before the end of this year, because we'll have our own legislation. So that will definitely enhance the position of the mediators in the country, because till now what we are missing in India is the sanctity behind the mediation settlements which happen outside court. People feel that the power of court giving an order or a judgment is more relevant than a mediated agreement, which we call as conciliated agreement outside the court. They don't have a sanctity. So people, if you have a problem in your business houses have 100 people, 20 people, any number of people, they have their issues within the various departments of the house. So if you have mediation or a conciliation cell in your own setup, it will prevent lot of conflict being inflated and going outside the organization, because the organization otherwise will definitely get demolished. If you have so much of negativity within your department, you need a team which works towards a common goal. But a team fighting within will not be helpful a person to run a business. So it's good that if you go through this, you can have your conciliation centers within, and then if you have some dispute outside your own country also, then online disputes, reconciliation, online mediation is happening. People are engaging us not just in our country but outside India also. They're engaging our service. So those boundaries have gone. We don't have to spend a lot of money traveling there, taking a visa, spending money on our boarding and lodging. So you can save the cost of going outside, and you can save that money to be invested in your own profession. So there are always a benefit attached to this. So I would request everyone, after this 3 days just lubricating session which Shravan and Riddhi and Vishali they've taken up, to please think of taking out time personally and maybe just become the ambassadors to spread that let's go to this 40 hours life transforming training, which will definitely give us an edge outside and inside our home front and in our country. So my good wishes to each one of you. There is I have not seen any side effects of mediation. It's always positive. So just be a mediator. There's a lot of scope. You can just cherish being a mediator and see peace around you. So my good wishes to each one of you, and my best wishes to my co-panelists. Looking forward for more such worthy comments coming. I hope I'm within my time frame. I'm able to share.
Yes.
Thank you so much, dear. Thank you.
That was a great speech. But actually, we are the ambassadors for entrepreneurs. The technical side.
Yeah.
Mediation actually is an amazing way of conflict resolution. I would have to agree to it actually, because even after going through so many countries, different mediation systems, and the ODR system especially, which has come up in the previous times, I'm quite impressed by it. But however,
Thank you so much, dear.
our
Best
focus is
wishes.
on entrepreneur.
Thank you.
Thank you. If you can just drop out your email ID in the chat box, Push, so that anyone can like mail you if they have one. Great. Riddhi?
Yeah. So I would like to thank Advocate Pushpa Gupta for her informative speech. It was an amazing opportunity to hear you. Now, I would like to invite Advocate Harbans Chaturvedi, Senior Advocate at the Supreme Court of India, to start his speech.
Thank you very much, Mr. Shravan and Ms. Advocate Riddhi.
Thank you.
I heartily welcome Dr. Teresha from Florida, my sister Advocate Pushpa Gupta, Madam Oksana, Dr. Mirja, Madam Begum. Today is our introductory session because 10 minutes for mediator or conciliator or for arbitrator. 10 minutes, this just goes for introduction. So in my today's arbitration, mediation and conciliation, these are the popular forms, dispute resolutions. My sister Pushpa Gupta has already discussed with regard to mediation, and she has beautifully explained as how mediation not only work in courts, in offices, in litigation like criminal and civil, but also it works in our home. If you are a good mediator, then you are able to mediate with your family, your friends, and in yourself as well. Important thing in the life is that if you are able to win yourself, this is the practice. Practice makes man perfect. Mediation, conciliation, arbitration. Arbitration is something different because arbitration is completely a trial method, evidence, arguments, reviews, claims, counterclaims, so many things. So this is like a trial, and decision will come after determination and adjudication. So arbitration is something different, which I'll take later on, though I'm arbitrator. And recently, I would like to tell Mr. Shravan that MSME reference were made to Delhi High Court International Arbitration Center under Section 18 of the Act, MSME Act, to arbitrate because conciliation was failed. Any party, if approaches the MSME council, then either council will take the matters by itself after failure of the conciliation. But if conciliation terminates, in India, this is the Act, MSME Act 2006, which is statutory provisions are there. So, two reference I received in Delhi High Court International Arbitration Center, which is known as TAC, Delhi International Arbitration Center. I adjudicated both. First issue was whether we have jurisdiction to deal with because MSME Act is totally different. The parties raise their objections, etc., etc. But if the reference is there and has not been challenged in any court, that becomes binding. Preliminary issue, I decided positive. And thereafter, I passed 2 awards. 1 award, both parties agreed, and they immediately after 2 or 3 weeks implemented the award, need not to go in objection. And that was my experience when reference came under Section 18 of the MSME Act. And after this MSME Act 2006, what I have seen in India, a great change, conciliation process, mediation process. I have just conciliation process, just I talked about conciliation. Conciliation, this takes me to back in 1947, when Industrial Dispute Act was enacted by Indian Parliament in 1947. Indian Parliament enacted this Industrial Dispute Act. Section 4 was the conciliation officers. Section 10 is the reference for conciliation. And even the provisions are there, even in Section 22, if you will read in that Industrial Dispute Act. During the pendency of the conciliation proceedings, I was reading the conciliation law in Canada, in America as well, USA. Mostly American conciliation in industrial law and Indian conciliation in labor laws, both are taken from the British. But by the time there are different mechanisms. So conciliation cannot be binding, whereas if there is award under the arbitration, that will be binding until unless it is not being challenged. Conciliator or mediator, they both cannot force their opinion. They both cannot take any decision during the conciliation or mediation. But arbitrator, while adjudicating the process, after completion of the pleadings, may frame the issues, call the party to prove the case. If there is counterclaim, then the respondent will also be allowed to prove the counterclaim. And then after argument, award will be passed, and that award will be binding if it is not being challenged. Conciliation, if failed, then like MSME, conciliation is failed or terminated, then reference will be made to the institution like Delhi High Court, Arbitration, International Arbitration Center. Or the authority council can itself may start arbitration. So there is a great change after this 2006 Act, MSME Act. And I'm telling you, in conciliation, mediation, which leads towards the arbitration, recently our parliament is also going to enact these provisions regarding mediation, etc. In India, what is for mediation? Suppose mediation agreement settlement is signed by the party. And if it is court annexed mediation, then the settlement will go to the High Court. If it is Supreme Court, then the Supreme Court. We in Supreme Court and High Court, if got recorded voluntarily the terms of agreement settlement with the signature of the mediator, that settlement agreement will go to the court, and that will become part of the judgment or decree of that particular court and cannot be challenged. So this is the win-win situation in mediation and win-win situation for both the parties. Rather, in arbitration, there is no win-win situation. One party will lose, another party will win. But in mediation, both party will win, and both party will resolve their own disputes by their own. They will be judges of their own resolution. Mediator is a facilitator, providing opportunity to both the parties. I am also senior mediator in Delhi High Court Mediation Center. My sister Push Gupta is also there. We are there. So, domestic mediation, divorce mediation. We have also psychologist room as well over there. So we are also taking the services of the experienced psychologist, as Dr. Teresa just explained how it is important and plays vital role while going on the mediation. My time is over. So what I was telling, that this is the introductory part. So I'm very happy that I have met with such great personalities over here. And Mr. Shravan, you keep it continuing. Whenever you will call us, we will come to your conference. This is our assurance. And thank you very much, because time is over. Thank you.
Thank you, Mr. Chaturvedi. Actually, that was a quite informative speech, especially the sections covered in particular. However, we would have more conferences on ADR in future. That's whatever. Yeah, Riddhi? Okay. Yeah, Mr. Chaturvedi, if you could just share your email ID in the chat box.
Yes, I'm sure.
I would like to thank Advocate Harbit Chaturvedi for his knowledgeable speech. Now, I would like to invite Dr. Amna Mirza, Assistant Professor at SPM College, University of Delhi, to commence her speech.
Thank you very much. Just want a big thumbs up. Can you all hear me? If everyone, okay, thank you, Riddhi. Thank you, Chaturvedi sir. Thank you so much. At the very outset, my namaskar, greetings to everyone. Thank you so much, Shravanji and SK Group, for having me. I'll be very honest here that I'm not from legal fraternity, but trust me, I'm really enjoying all the inputs that you are all presenting, and especially the area in which I'm working. It definitely pertains to the important issues that are being raised by all of us here. Now, the topic that you all have given it to me, especially trying to look at arbitration. I'm going to look at the issue from an academic perspective, and of course, an academic perspective that tries to touch upon certain important insights with respect to the legal fraternity also. And trust me, thank you so much, Shravanji. It's a matter of great delight and honor. I'm so happy to be there learning with the wonderful legal luminaries here. And I was listening to the important insights presented by Dr. Teresa, Pushpaji, Shravanji, Chaturvedi sir before me. The topic wherein which I'll try to present my academic perspective is globalization 4.0, and how do I situate arbitration here? Now, I also have a PPT I've shared. I'll be sharing the PPT with Shravan sir, so that can be shared for future this thing. But I'll try to keep it for the 10 minutes that you have allotted me, like in the form of an extempore. My talk is divided over two parts. In first part, I'll try to dwell on that what is actually globalization 4.0. And in the second part, I'll try to look at that where do the legal aspect, the arbitration aspect comes in, And then what are its demands? And again, these are my academic viewpoints. Feel as a teacher, as an educator, as a researcher, these are my perspectives. Feel free to disagree with that. Now, globalization, we all know, is a very contested concept. By contested concept, I mean that it has always existed. For example, when I think about the Silk Route, long back in 5th century BC, the idea of trade, interchange, and exchange has always existed in human civilization. But dear friends, legal luminaries, distinguished delegates, let's understand that, especially when you look at human history, in the post Cold War era, or what we can say the time where forces of information and communication technology completely revamped how do we connect, completely revamped the idea of trade, interrelations, and inter-exchange of goods and services. Earlier, trade it was just about goods. Today, we are seeing that trade is becoming so complex that it's about trade and services. Now, this globalization, at one point, it gave us rise of big MNCs, but at the other side, there were issues of job loss, trade rules, employment rules, negotiation. At one side, it did give us a scheme of a definite trade apparatus like the WTO, whereas at the other end, you were all erudite legal luminaries, from patents to copyrights to trademark. It indeed opened up a huge Pandora's box when it comes to various issues concerning global business, concerning local laws, amongst others. Now, dear friends, we all know that globalization has been contested. For example, we see that there's a cry that all over the world that let's roll back globalization. When we try to hear the arguments of then US President Donald Trump, when there is a call that I'm going to make Mexico pay for the war, there is this idea that this global trade was not balanced. It was not equal. And this is why there is a need to reform it. There's a need to do away with it. We saw the world pulling out of we saw the United States pulling out of Paris Peace Agreement. We saw that at one point in time, world was witnessing growth. But at the other point in time, this growth was somewhere not favoring the environment, was not favoring the concerns of the grassroots. Now, with this context of complete call of rollback of globalization, the 2019 World Economic Forum at Davos presented a new insight. And this new insight was that at this forum, the call for globalization 4.0 was given. Now, we all know that technology has always had an important influence on human lives. So globalization now, from a first wave, wherein it was primarily about trade and exchange, the second wave where it was about the idea of exchange being, further increased further, to the third wave and to the present phase, wherein it correlated with the fourth industrial revolution. Again, if you just look at the parallel aspect from, wind energy to steam energy to automation, or to the bigger picture that we have right now, Industry 4.0, talking about mechanization. So globalization, like industrial revolution, has had various phases. And right now, the world is in the phase of globalization 4.0 and Industry 4.0 in the parallel aspect. Now, we all know that laws are very important to answer the questions of the context. Agar hum Hindi ka main thoda sa, because I do I write a column, so I do 4 languages in my academic columns that I do for newspapers: English, Hindi, Urdu, Malayalam. So what we see here is that the text has to correlate to the context. We know that the world has been redefined. Today, data is the new currency of power. We're all living in digital age. We're all living at the time wherein, codes and technology is revamping our life. So in this aspect, there is a debate that with globalization, with the advent of new technologies, how would the legal terrain really cater to this big problem? Not problem, but the new constraints that would be developed. So here it's seen in this aspect, and again, we're all debating and discussing arbitration. I was listening to the very important insight presented by Pushpa Ma'am, wherein she pointed out that there's a need for, we must undertake mediation, training in mediation, or for that matter, how Dr. Teresa was also pointing out the important remarks in her session. So from an academic point of view, someone who's working on globalization 4.0, I like to, present this aspect that yes, globalization 4.0 has just begun. It is going to be very hazy. It is going to be beneficial also. So in order to translate the opportunities this new phase of globalization has, it is very essential that we must have sound dispute resolution mechanisms. And this is why the role of legal practitioners like you all becomes really important, because you have to guide the world with respect to this new resolution mechanism, adding more dynamism to arbitration. Secondly, I like to draw your attention to the international conference on arbitration in the era of globalization. This was at the 4th edition, organized by Indian Council of Arbitration, ICA. And therein, the then Chief Justice of India, C.V. Ramanaji, also said that arbitration is best suited dispute resolution mechanism for the globalized world. And as an academic who's working on this discipline, I really add to that why arbitration becomes very useful, because defining characteristics of this globalizing world, especially globalization 4.0, is disruption. We are living a time where disruption is constantly posing new challenges to us. For example, today I get up with a set of information. I don't know that after half an hour or after that 1 hour, will that set of information which is the currency of power, will it be valid only? So how do I then work out my contracts? How do I work out the new issues concerning my laws? How do I listen to voices of various parties and stakeholders? Because every process of contemporary times, it is plural in approach. You cannot have a unidirectional aspect. So seen in that aspect, yes, arbitration is definitely will definitely offer a very important advantage. Secondly, when we are looking at the arbitration aspect, I was keenly listening to Chaturvedi sir. Sir, it's very important that and I think the legal fraternity must voice it out, that alongside pressing the need for significance of arbitration as a very important dispute resolution and settlement mechanism, so this process must be there for the benefit of the common man too. Because today issue, judiciary over the period of time, we all know that it is a beacon of hope for many. But the very process, the very idea that the process becomes a punishment itself, the common man definitely, and even for that matter, even the corporates for that matter, they somewhere feel wary. So I think there is a need to instill confidence on part of arbitrators too, that people who will be parties to the arbitration process, people who will be parties to the mediation process, it would be a beneficial way out for them too. Because let's accept that the second point which I wanted to address with respect to globalization 4.0 and the important challenge that it has for our legal domain, that we are living at a time of that there's a need of constant learning and engagement. And I think especially, on part of legal fraternity, this idea of learning and engagement becomes again all the more. So then legal fraternity too, using the arbitration mechanism, must try to put things in a simple format, because things are getting complex, right? And of course, any party would demand a simple perspective of a simple problem solving mechanism. So yes, it is imperative that complex times demands an innovative approach where simplicity should be a guiding criteria. So with these two important aspects, I really say that globalization 4.0, again, if I would really urge upon you here as a researcher, as a academic here, that one must, reflecting on the important literature that's coming in from the World Economic Forum debates and the other related developments that are taking place in various countries. It is very important to understand that one has to safeguard national interests, safeguard the local, and then, of course, develop the competency and reach out to the global. Now, in this complementary and supplementary aspect of global and local, and wherein we are saying that today massive range of technological innovations, and today technology is we all saw that even in a pandemic, regardless of that, are how our homes were converted into workplaces. So it is demanding new work-life balance. So seen in this aspect, yes, one has to engage with globalization 4.0. Isolation can no longer be an option. And when isolation is no longer an option, then yes, legal fraternity definitely has an important role to play. And this role should be summed up in two mechanisms. Please feel free to correct me because I'm talking again from an academic perspective, and I'm trying my best to put it down from a practical legal sphere too. That is, firstly, there is a need to really broaden the scope of arbitration. There's a need to ensure that even a common person feels connected to that. So simplification, and yes, at the same time, one has to really understand that in present time, arbitration as an important dispute resolution mechanism is an important pillar. The onus is on very important responsibility is there on part of the legal fraternity, on part of related research community, the media, to really instill confidence to take things forward here. So on that, I like to really sum up my perspectives here that yes, friends, globalization has always been an important phenomena, really guiding human civilization. Globalization has various dimensions from economics to psychological to political to social to cultural. But yes, all these dimensions have been contested. Like at one point of time, we did gain the global business, but at the same point of time, there have been voices of neglect of the local. At one point of time, we did have the global legal regime, but at the same time, there has been concerns of democratic deficit. But regardless of the pros and the cons, the process is here to stay. And one of the important guidelines guiding this process now is this rampant wave of technological advancements, communication revolution, and they are here to stay. We all saw that yesterday India celebrated the Independence Day, and right at the at the time of celebration of independence, it was the call was given said that India's tech aid is here. So now, when the next decade will be led by technology, and we have global forums talking about that, it is the age of globalization 4.0, industry 4.0, advent of new technologies. It is very essential then in the present scenario that legal fraternity must try to comprehend the important message that these new changes have in store for laws, and yes, at the same time, try to understand that this mechanism is very important. This is the best suited mechanism, as it has been said at various legal conferences also, but there is a need to simplify it. There's a need to boost the confidence of both of all the parties who will be involved therein, and the way out could be having an innovative and a simplistic approach and a mindset to simplify things. So once again, I rest my case here. And friends, respected delegates, as I said, that I'm an academic, I'm a professor at the university, and of course, I write articles, reflecting on international political economy, global governance, and yes, globalization 4.0 is, as you all know, it's an important contemporary development, and legal fraternity too will have its bearing. So we hope that we are all on the same page to equip ourselves, to prepare ourselves, because again, an important caution that was given by Klaus Schwab, the founder chairman, the executive director of the World Economic Forum, that globalization 4.0 has just begun and we are vastly underprepared for it. So there's the need of the hour is that earlier visions of globalization, what was faulted was that somewhere we did not learn from the past, and that past demanded to make it an inclusive approach. So it is essential that we must try to have an inclusive outlook towards globalization 4.0. Let it percolate down, let it decentralize. Laws at the same time cannot then just exist in a vacuum. Laws too, the legal fraternity too, the legal terrain too, has to take up this challenge, and arbitration therein will be a practical mechanism to offer a way of hope for everyone. So we hope that you all do wonderful work in arbitration, discuss new dynamics, and factor in these dynamics to get, to more offer better propositions for the business partners, amongst others. So thank you so much, Shravanji. Gratitude. Thank you so much for having me. My greetings, my namaskar to everyone. Thank you. I hope I try to keep myself as simple as possible. So
that was a great speech, actually, Ms. Mirza.
And feel free to put down your questions or remarks in the chat box.
Yeah, that's actually great. The point that you put up in the front, information is the currency of, I could not grab the last word, if you just repeat it once. Just unmute yourself, please.
Shravanji, what I was trying to say that today information is the key, right? But this information as a factor of, if I look at from an economic process, it was earlier like land, labor, capital, enterprise. But today this information is becoming an important factor of production. And what we are seeing here is then with this digital aspect adding more inputs, Shravan, then it is very essential, especially on your part as legal practitioners, that how do you then situate arbitration in this rapidly changing context? That was an important point that I made. In fact, today only, though it's in Hindi, you can check it at my social media pages. I've written an article that, and it's there in a popular Hindi portal, Punjab Kesari, that of course we are in the tech aid, and tech aid is bound to offer more opportunities. But let us now think that how do we decentralize it? So again, on part of legal fraternity too, and again, this issue cuts across North and the South. Regardless of whether we are in the global North or we are in the global South, whichever part of the globe we are in, there is a need to decentralize this technological advances. There is a need to decentralize globalization 4.0. And the moment I do that, Shravan, when I decentralize things, legal fraternity is bound to witness rampant changes, and it has to be prepared, because if you guys are not prepared with respect to, because problems are bound to arise, because there will be perspectives and counter perspectives. When we have the structure of the legal apparatus to guide us, to let things forward, then only a better sense of this contemporary prevailing phenomena can come out.
Point. That was actually a great speech, Mrs. Mirza. If you could just share your mail ID in the chat box.
I'll just do that right away.
Riddhi?
I would like to thank Dr. Amna Mirza for her informative speech. I would like to invite Ms. Begum Mukhotinwa, founder and CEO of Business Soft from Kyrgyzstan, to commence her speech.
Hello to everybody. My name is Begum. I'm from Bishkek, Kyrgyzstan. It's a great honor for me to present such a significant and large-scale event and talk about the development of arbitration in Kyrgyzstan too. First of all, I would like to thank all organizers of today's event and for your invitation and opportunity to exchange our professional experience and also outline further ways of development and borrow the experience of our experts in the field of extrajudicial methods of dispute resolution. And in my opinion, from the point of view of saving time and costs for professional representation of the parties in court and other costs that accompany any legal dispute, the arbitration court is most effective and profitable. For example, Kyrgyzstan has all conditions for commercial disputes to be arbitrated. And this includes legislation, permanent arbitration institution with highly qualified international arbitrators. And also vast experience in administering arbitration of any complexity. Moreover, every year, the number of individual entrepreneurs who are potential participants of arbitration courts increases, as well as the scale of business as a whole. And our International Court of Arbitration, in affiliation with the Chamber of Commerce and Industry of the Kyrgyz Republic, recommends an arbitration clause to include in all agreements. And as for me, I am an interpreter. I also include the arbitration clause to my agreements with our clients. And I think that arbitration is one of the effective measures to protect the rights of the parties and resolve disputes between them arising from the international commercial contracts. And according to the practice, the parties of the disputes agree that the decision of the international arbitration is final, binding, and not subject to appeal. And our International Code of Arbitration, in affiliation with the Chamber of Commerce and Industry, is a permanent independent body providing prompt and highly quality resolution of economic disputes in business environment through independent professional arbitrators. And our list of arbitrators includes more than 300 specialists from 28 countries. What are the specific advantages of arbitration? Firstly, the parties to a dispute can choose arbitrators whose honesty and professionalism they trust. It will be not only a Kyrgyz citizen, but also a foreign citizen can be chosen as an arbitrator. And secondly, the speed of dispute resolution. The International Arbitration Court, a dispute is considered in one instance only. And in a competitive environment, the short time frame and speed of dispute resolution are important components in choosing a method of protecting rights. And also, in addition, the finality of the arbitral decision without the possibility of appealing on the merits, which is the liking of entrepreneurs. And the third plus, the confidentiality of dispute resolution. No information about the parties and the subject of the dispute. The content of the decision by arbitration is not disclosed. And arbitration awards, unlike other courts, are not published and not posted in the internet arbitration awards. And fourthly, the decision of the international arbitration comes into force immediately after it's delivered and can be enforced in 142 countries of the world. And today, when the domestic business enters the international level, the opportunity to include in the contract's arbitration clause will allow the businessman to be sure that any dispute arising from the contract will be considered by professionalism and in the best possible time. Also, an additional advantage of our arbitration court is the digitalization. Our court has developed the arbitration cabinet, which allows the parties to review case materials, attach documents, submit motions, and send statements of claim in electronic form. By means of this, it is possible to conduct arbitration proceedings online. This is very convenient for the parties of the judicial process. For example, during a pandemic situation and thanks to digitalization process, the arbitration is not tied to geographical location of the parties or the arbitrator. And a resident of even the most remote corner of the country has the opportunity to participate in arbitration process through a remote process. Also, we're developing a unique international platform for alternative dispute resolution. This is a common base of actual legislative acts. At the moment, we have also a program of delivery of all correspondence of the arbitration process for timely informing the parties to the arbitration proceedings about the receipt of the claim, the date, time, and place of the hearing, and furthermore, we try to make the arbitration procedure is more easier. And every year we publish a collection of articles on current issues in arbitration and mediation. We also invite all participants to publish in our collection. And I can give my email address in the chat, and you can send me maybe your proposals. Our court is open for cooperation with other arbitration institutions and centers to maintain constant communication, planning and hold business meetings to familiarize with the legislation of other countries, regulation, rules, and developing in the international arbitration field. I think that it is necessary to continue actively strengthening the connection of Kyrgyzstan with the largest arbitration institutes. And we have set certain goals for the development of the business community of Kyrgyzstan and outlined the ways and methods of their implementation. A lot of work lies ahead, and the result of which will be the development of
Excuse me, Pegam, if you could wrap up in 2 minutes, we could have a Q&A session too.
What?
If you could just wrap up in 5 minutes, we could have a Q&A session with all the attendees. That would be great.
My time is over.
No. You can take 5 minutes more. That would be great.
Okay. Okay. And also allow me, dear conference participants, to express my confidence that all of us together will be able to find effective and adequate mechanism for promoting sustainable economic growth, developing our economy, and protecting human rights. I think that it's our main task for the future. And as the practice shows, business in Kyrgyzstan, especially foreign investors, have welcomed the opportunity and have already shown their readiness to resolve their disputes in arbitration courts. And today, many companies already include in their contracts an arbitration clause, and me, as an interpreter, also try to develop and discuss about arbitration. And I'm very glad that I work in both IT area and arbitration. I think that this is the most topical areas of activities. And thank you for your attention. I wish you success.
Thank you, Begum, for your amazing speech. You were like quite informative on certain points of arbitration and nobody covered, especially on that point we mentioned the Kazakhstan laws. Thanks for that.
Thank you.
Now, I would like to request all the attendees to put forward your queries to the entire panel at once. I have been like missing out the individual one-on-one Q&A session, but here we do have the joy. Any questions out here? You can simply unmute yourself and ask any of them. Yeah.
Okay.
Arushi, any questions today?
I have one.
Definitely. You may address it when you're comments.
So here there is good evening. So good evening, all of you. I just want to ask one question: that how does ADR practices help to alleviate the scope of law? Should I repeat it?
The question for me?
No, to all of you. Whoever volunteers to answer it.
Mr. Chaturvedi, would you like to answer this?
Very well. Very well, Arushi. This is a very good question. You are studying in which first year, second year,
No, sir.
final year of law?
Yes, sir. No, I'm not from the background of law. I've just graduated with BCom honors degree from Delhi University.
Very good. And thereafter, you have joined LLB?
No, sir. No, sir.
Okay.
Actually, sir, I have persuaded for the professional exam. This time I'm going to give my first attempt December in ICWA. And
Okay. Okay. So, what is your query? Just you repeat.
so I've asked that how does ADR practices help to alleviate the scope of law?
ADR practice, how help to the
Yes, sir.
legal fraternity or other people?
No, sir. Just
for legal fraternity, advocates, lawyers, or legal persons, or other side is other people.
No, sir. I've said that, sir, when there is a law, so there is certain knowledge into the law, and the arbitration is a process that we take that is not that is not in the scope of law. So I'm saying that
Arbitration itself is a law. Earlier it was 1940 Act, which was later on new act came in 1996. Arbitration. So this is law. This is taught in LLB when you will study the LLB classes. So this is law enacted by the Parliament. After 18 years, 100 years will be in India, if we count from 1940 Arbitration Act, same has been out of court resolution of the dispute, which can be resolved by mechanism of similar to the court, but in a short period of time. Big cases we are deciding in a 3 months, 4 months, or maximum in 6 months. During the pandemic, even we have, as per rules, there are in each high court, there are ODR rules as well, online dispute resolution. So even online, we have conducted the examination in chief, cross-examination, and we have conducted all the proceedings, and thereafter, finally, after hearing the parties, we have passed the awards. So nowadays, the arbitration, mediation, conciliation, all are very much in the stream and are very much beneficial to all the students who are interested to study law and who are interested in ADR system.
So, but I wanted to ask, I was saying that how does ADR practices help to increase the scope of the other laws? For example, any law you can take any commercial law. So, that how the scope of law is increased. I wanted to.
Your question is, if I rightly understood, you want that how arbitration law increasing the scope of other law.
Yes, sir. Yes, sir. That was my question.
Okay, so answer is the arbitration law is reducing the pendency of lot of cases. Arbitration law reducing the pendency of the court cases, reducing the pendency of the tribunals cases, pendency of the cases which are since long pending in the courts. So in that way, the arbitration is helping to reduce the other cases. So your answer is there, I think.
Oh, yes, yes. Okay.
Yeah, great. Thank you, Mr. Chaturvedi, for your answer. Now, I would like to request if anyone else has any questions.
Yes, sir. So I have one question.
Great.
Yes, please.
Yes, sir. So how can we become the arbitrator? Means if someone want to be arbitrator, so the means we need some kind of certification in it. Means some kind of experience. Means everyone saying that you need some kind of experience for making particular arbitrator. So it's very difficult just because you're not getting internship directly in the particular one, and it's very difficult for means if you don't know anything about it. So how can we do this thing?
Yes, I'm giving the reply in a very short one line. This is the Delhi International Arbitration Center. If you will type in Google,
Yes,
Delhi
yes, sir.
International Arbitration Center.
Yes, sir.
Recently, the applications from the eligible persons for becoming arbitrator were called. Just you see that in website, you will find the criteria, eligibility, qualifications, everything is there for everyone. This answer is for everyone. Answer is there.
Yes, sir. Okay. Thank you, sir.
Now, I would like to request if anyone has any questions into mediation. Any specific questions? Any other queries?
I have one.
Perfect. Yeah, Arushi. Push, if you are still online.
Yes.
Just a moment. Ms. Gupta, are you still online? I guess.
I think so, Ms. Gupta is left now.
Okay. Arushi, you can put your question.
So my question is that institutionalized arbitration leads to the creation of these self-contained and self-governing trade groups in an organization. So is there a possibility that commercial arbitration can replace the need of court, especially in the commercial disputes?
In commercial disputes.
Yes, sir.
You know, the answer is very simple. In commercial dispute itself, there is contract.
Yes.
When two parties are contracting any commercial transaction for any commercial work, there must be some contract. And nowadays, in each contract, there is a specific arbitration clause in each contract. And if there is arbitration clause, then the judgments of the Supreme Court and various high courts are then that matter must be first referred for the arbitration. And if it is not referred, one party has filed the suit in the court of law, then other party either can take objection in written statement or can file an application under Section 8 of the Arbitration Act itself that, look, this is the arbitration clause in this contract. This must be referred to the arbitration. So your answer is yes, this can be done. Substitute there is this, then the arbitration award will be passed. When award will be passed, then the parties will challenge that award. So at least one process for litigation, court litigation, will be avoided. Got your answer?
Is there a possibility that this commercial arbitration can really replace the courts? Matlab in future,
Courts cannot be replaced at any time. Courts are courts, and without courts, you cannot run any institution. Because ultimately, if award will be challenged, where you will go? You will go to the court. If award will be faulty, where you will go? You will go to the court. And even in India, there are 4-tier systems. In criminal law, magistrate, session court, high court, then Supreme Court. In civil, then the civil judge, then the district judge, ADJ, additional district judge, then the high court, then the Supreme Court. Why this system is here? To at least give the justice. If all are human beings, somewhere everyone may commit mistake without knowing. So courts will be never replaced. You take is as the thing that courts are courts and cannot be replaced. Courts work, courts litigation can be reduced by way of alternate dispute resolution through arbitration, through mediation, through conciliation. Suppose for arbitration, if contract arbitration clause is there, then the award will be passed. Court is not being replaced, but simultaneously other forum has done that court work, but later on that will be, if you want to challenge, where you will go? You will go to the court. So courts, in that way, courts are not replaced, but in another manner, the alternative dispute resolutions forums are supplement to the court, not for replacing of the courts.
That was actually a great perspective, Mr. Chaturvedi. And Arushi, like mediation, arbitration are ways of reducing conflicts and dispute. But when you come to law is actually very important. Example, in criminal cases, you can't exactly apply mediation. Law would definitely come into effect automatically. Whatever has to be done shall be done by the judiciary and the system. Mediation isn't used. Everything has a limit, I guess. That's the limit of mediation and ADR. Okay. Any more questions out here?
Sir, I have one more question.
Yes.
So, if we choose in between three of them, means mediation, arbitration, and conciliation, for the beginner, which area is more relevant? Means we have to start with something, and it's easy to us to start with this thing. Means if we want to start something in three of them.
Yes. I got your question. If you must have seen, meanwhile, the eligibility criteria of the arbitrator, that is either he should be the retired judge or must be practice of 10 to 15 years or
Yes, sir.
so and so or retired district judge or so many things. But I am telling you, if you are choosing the mediation, then after this MSME Act 2006, great change has taken place in this area. I was studying one case. Let me come first answer to your query. If you are a mediator and if you have 40 hours training, you got the certificate as a trained mediator. Then, I was studying this the company's mediation and conciliation rules 2016. These are emerging. Earlier, there were no rules for mediation in Company Act 1956. We were fighting for liquidation, winding up, everything, but there were no such rules. Now these rules, these are the rules, and your answer is qualification for empanelment as a mediator. Start: A has been a judge of Supreme Court, B has been a judge of High Court, C has been a district and session judge, and then the F is a qualified legal practitioner for not less than 10 years. But last I is Rule 4, Sub-Rule HI, is an expert in mediation or conciliation who has successfully undergone training. That's it. So this is so simple. You see the intention of the parliament. This is the parliament enacted everything. So you see the intention of the parliament, that how they want to make mediation in the society and how they want to flourish this mediation. Eligibility is only certificate, nothing else. So mediation is the best. Conciliation and mediation. Thereafter, you will automatically, when you will start mediation, you will become the arbitrator. What I did earlier, I will take 1 minute. When I started my practice, then pro bono, I have started giving my services to Supreme Court Legal Services Committee. Pro bono, I have started giving my service to Delhi High Court Legal Services Committee. And there, what I started doing, I started taking mediations, lok adalats, everything in pro bono. When I got little more experience, automatically my name was suggested for the arbitration as a arbitrator, and that too in Delhi High Court International Arbitration Center. Thereafter, so many other institutions have also taken my name. So this is a start. Our Prime Minister, I was listening yesterday, if you must have listened, respectable Prime Minister was saying that his speech was in Hindi. And
excuse me, Mr. Chaturvedi, actually, we are running a bit high on.
One second. Only one second. बनने के लिए अगर आप सोचेंगे तो फ्रस्ट्रेशन कहीं ना कहीं आएगी. जो बनना है वो करने के लिए अगर आप सोचेंगे और वो करते रहेंगे तो आप अपने आप वहां पहुंच जाएंगे और बन जाएंगे. Thank you.
Thank you, sir. Sir, one more question. You said. So just last question.
Exactly, we're running on a constant. We have 5 minutes.
Otherwise, I'm here. No.
So it's quick question. So you said we need a certification. So it's means we get the certification from the particular registered.
After 40 hours trainings, there are recognized institutes for me. If you will get the 40 hours training over there, then you will be given the certificate and you will be the trained mediator.
Okay. Thank you.
Oh, Mr. Chaturvedi, if you could just share your mail ID in the chat box.
Yes.
The question.
I'm again sending, though I have sent earlier, but now this is again I'm typing.
ADR is actually a very vast topic. Now I would like to wrap up this session by thanking all my guest speakers and my fellow speakers and all panelists for cooperating and helping us organize such a wonderful conference. But however, we'll come back tomorrow with session 3 of conference 1.2 on emerging entrepreneurial trends in arbitration, mediation, and ADR. Till then, stay tuned and have fun.
Thank you.
Thank you, sir.
Thank you.
Thank you.